Alternative dispute resolution (ADR) mechanisms. Alternative dispute resolution. Alternative dispute resolution (ADR) refers to a set of processes and techniques used to resolve legal disputes outside of the traditional court system. ADR mechanisms are designed to provide parties with more flexibility, efficiency, and control over the resolution of their conflicts. These ADR mechanisms showcase the variety of options available for resolving disputes outside of traditional litigation. The choice of the most suitable ADR method often depends on the nature of the dispute, the preferences of the parties involved, and the desired outcome. Here are some common ADR mechanisms. Mediation. Mediation is a voluntary process in which a neutral third party, the mediator, facilitates communication and negotiation between disputing parties to help them reach a voluntary and mutually acceptable resolution. Mediation is a non-binding process where the mediator assists parties in identifying issues, exploring options, and reaching a settlement. The mediator does not impose a decision but encourages a collaborative approach to dispute resolution. Examples: workplace mediation. In a workplace, employees may mediate disputes over issues such as interpersonal conflicts, harassment, or disagreements about work assignments. The goal is to restore a positive working relationship. Community mediation. In community settings, neighbors might engage in mediation to address disputes related to noise, property boundaries, or other issues affecting the neighborhood. Arbitration. Arbitration is a process in which a neutral third party, the arbitrator, hears evidence and arguments from disputing parties and makes a binding or non-binding decision to resolve the dispute. Arbitration can be either ad hoc or administered through an arbitration institution. The decision of the arbitrator is final and legally enforceable in binding arbitration. Examples: commercial arbitration. Businesses often include arbitration clauses in contracts to resolve disputes. For instance, if there is a disagreement over contract terms or performance, the parties may submit the matter to arbitration rather than going to court. Consumer arbitration. Some consumer agreements, such as those for credit cards or online services, include provisions for arbitration. In case of a dispute, consumers and companies may opt for arbitration as a faster and less costly resolution method. Negotiation. Negotiation is an informal process in which parties directly engage in discussions to reach a settlement or agreement without the involvement of a neutral third party. Negotiation allows for direct communication, and parties retain complete control over the decision-making process. The outcome is not binding, and parties have the flexibility to explore creative solutions. Examples: business negotiation. Companies may negotiate terms of a contract, including pricing, delivery schedules, and payment terms. Labor negotiation. During collective bargaining, labor unions and employers negotiate employment terms, including wages, working conditions, and benefits. Conciliation. Conciliation is a process similar to mediation, where a neutral third party, the conciliator, assists disputing parties in reaching an agreement. The conciliator may take a more active role in proposing solutions. The conciliator helps parties communicate and understand each other's perspectives, facilitating resolution. Conciliation is often used in family disputes, labor conflicts, and international relations. Examples: labor conciliation. In labor disputes, a conciliator may intervene to help parties reach an agreement on issues like wages and working conditions. Community conciliation. In neighborhood disputes, a conciliator may assist residents in resolving issues related to noise, property boundaries, or communal spaces. Collaborative law. Collaborative law involves parties and their attorneys committing to resolving disputes through cooperative, non-adversarial negotiations. The process often includes a team-based approach. Collaborative law encourages open communication and problem-solving to achieve a mutually beneficial resolution. If the collaborative process fails, attorneys must withdraw, and litigation may ensue. Examples: divorce collaborative law. Couples going through divorce may use collaborative law to address issues like property division and child custody without going to court. Business collaborative law. Business partners in conflict may use collaborative law to negotiate solutions and preserve their working relationship. Online dispute resolution, ODR. Online dispute resolution, ODR, leverage technology to facilitate the resolution of disputes through online platforms, often involving communication, negotiation, and even virtual hearings. ODR platforms provide a digital space for parties to engage in various ADR processes without the need for physical presence. Communication tools, document sharing, and video conferencing are utilized to enhance accessibility and convenience. Examples: e-commerce ODR. Online marketplaces use ODR to resolve disputes between buyers and sellers over issues like product quality, delivery, or payment disputes. Domain name dispute ODR. In cases of domain name disputes, ODR platforms facilitate resolutions between trademark owners and domain registrants. Mini-trial. A mini-trial is a structured process involving a summary presentation of each party's case before a neutral advisor. The advisor then facilitates settlement discussions. Mini-trials often involve a condensed version of the evidence and arguments that would be presented in a full trial. The goal is to provide parties with an early assessment of their case's strengths and weaknesses to encourage settlement. Examples: corporate dispute mini-trial. Companies involved in complex disputes may use a mini-trial to present key issues and evidence to high-level executives for settlement consideration. Construction project mini-trial. Parties in a construction dispute may participate in a mini-trial to discuss issues such as project delays, cost overruns, and contract breaches. Ombudsman. Ombudsman services involve a neutral third party, the ombudsman, who investigates and facilitates the resolution of disputes within an organization. The ombudsman serves as an independent and impartial intermediary, assisting individuals in resolving conflicts informally. Ombudsman services are common in educational institutions, corporations, and government organizations. Examples: university ombudsman. A university may have an ombudsman to address student grievances, faculty disputes, and conflicts within the academic community. Corporate ombudsman. In a large corporation, an ombudsman may assist employees in resolving workplace conflicts, ethical concerns, and interpersonal issues. Med-Arb, mediation-arbitration. Med-Arb combines elements of both mediation and arbitration. Parties attempt mediation, and if unresolved issues remain, they proceed to arbitration with the same neutral third party. The process begins with mediation, and if mediation fails to resolve all issues, those remaining are subject to binding arbitration. Med-Arb provides flexibility while ensuring a final resolution for unresolved matters. Examples: employment dispute Med-Arb. In an employment setting, parties may first attempt mediation for workplace conflicts, and if unresolved, move to arbitration for specific issues. Commercial contract Med-Arb. Parties in a commercial contract dispute may choose Med-Arb to initially mediate, and if necessary, arbitrate specific contractual breaches. Summary jury trial. A summary jury trial simulates a trial before a jury, but the jury's verdict is advisory rather than binding. Parties use the experience to guide settlement negotiations. The jury is presented with abbreviated evidence and arguments to provide a non-binding indication of how a full trial jury might rule. The goal is to help parties assess the strengths and weaknesses of their cases and promote settlement. Examples: personal injury summary jury trial. In a personal injury case, parties may opt for a summary jury trial to obtain feedback on liability and damages before deciding whether to proceed to a full trial. Product liability summary jury trial. Manufacturers facing product liability claims may use a summary jury trial to gauge potential jury reactions and explore settlement options.